One of the questions we get from time to time from probate or estate planning clients is this: what's the difference between owning property as joint tenants with right of survivorship or owning property as tenants in common? Hi, I'm estate planning and probate attorney Joel Beck with Peach State Wills and Trust, and I'll answer that question in today's video. So today's question is this: what's the difference between owning real estate as joint tenants with right of survivorship or owning it as tenants in common? Well, in Georgia, those are the two main ways that two or more people can own real estate together. With a joint tenancy, also called joint tenants with right of survivorship, two or more owners own a property together in such a way that when one owner dies, his or her interest in the property automatically passes to the surviving owners. And when there is one owner left, he or she owns it all. That means that a joint tenant does not have an interest in the property that can be given to somebody else via a will or a trust, for example. Here's a common scenario using joint tenancy. Suppose you have a man and a woman, they're married, and they buy a house together. The property is deeded in both of their names as joint tenants with right of survivorship. Suppose the husband then dies. Upon his death, the wife owns all of the property, of course subject to any mortgage or security interest, and the husband's estate has no ownership interest in the property. The moment the husband died, the wife became the sole owner of the property. Now, for that reason, owning property as joint tenants is a common estate planning method. And often when couples buy a house together, it is deeded in that manner, but it may not be. Our other main way to own property in Georgia with two or more people is called tenants in common. With tenants in common, or TIC or TIC, one owner has an undivided interest in the entire property. Let's go back to our husband and wife example. Suppose that they buy a house as tenants in common. The husband dies. But because it's held as TIC and not as joint tenants with right of survivorship, the husband's interest in the property now belongs to his estate, and his will, or the laws of intestate succession if he had no will, is going to control and determine where his ownership is going to go. Is it going to be passed down under his will through probate, or is it going to be passed down to his heirs through the probate process? So typically, when a couple owns a property as tenants in common, upon the death of the first spouse, the property will need to go through probate for it to be distributed to the decedent's beneficiaries or heirs, depending on whether there was a will or not. If the property was held as joint tenants with right of survivorship, that property, on the other hand, would generally not go through a probate process on the first of the joint owners to die, and instead the entire property would immediately be vested in the surviving spouse. On the second to die, the property would then generally go through probate unless the surviving owner had added another joint tenant to the deed or had placed the property into a trust, for example. Knowing how your property is owned and what happens to it when you die is important to ensuring that your goals and objectives will be known and followed through as part of your estate plan. If you have questions about estate planning in Georgia, visit us online at peachstatewills.com. You can request our free guide to estate planning there. You can also find more information about estate planning and probate at our blog there at Peach State Wills, as well as on our YouTube channel. And if you need help with an estate planning or probate situation, give us a call at 678-344-5342. Finally, if you think this video was helpful to you, give us a like and subscribe to our channel to get more great content. And go ahead and share it with others who may find it helpful. Thanks.